Hey guys, can you hear me?
Yes.
Hi, Dave. It's Mike.
Hey, how you doing?
All right. Oh, good. I think that, Kelly, everybody can hear us, but only. Okay. So everybody can hear us, Dave, but I think only we can talk right now. Just so you know.
Got it. Thank you.
Yep. I think we have, looks like a good amount of people starting to call in here.
Hello everyone. We're going to give this another minute or two as we continue to see people calling in and logging in. So just another minute or two and we'll get started. For those of you just joining, we're just going to, one more minute here, allow a couple more people to join in, and we will get started here very, very shortly. All right, let's kick this off. Hello, everyone. Good afternoon. It's David Levy, one of the partners here at Diversified, and I'd like to welcome you to our next installment of Wealth Webinar Series, Estate Planning in the Wake of the Pandemic. In a moment, I will welcome Michael Salad. Michael is a partner and attorney in Cooper Levinson's Business and Tax and Elder Law practice groups. He concentrates his practice on business transactions, tax matters, probate administration, and estate and business planning. Per usual, we'll look to keep this about 30 minutes to get you back to your day and to make things as efficient as possible. We will be accepting questions as we go along. Please enter them, and if you have any questions at the end, if time permits, we'll take a couple additional questions at the end. And then if for whatever reason we can't get to all of your questions during this 30 minutes, please reach out to us and we'll be happy to answer them or get you in touch with Michael if needed. So with that said, Michael, let's get this started.
Very good. You got it. Thanks very much, David. I appreciate the kind introduction and the opportunity to speak with everyone today. Welcome, everyone. As David said, I'm an attorney with Cooper Levinson, and my primary area of focus is estate planning and elder law and probate administration. And today I wanted to discuss specifically some issues that have been arising over the last 2 to 3 months in the wake of the pandemic. I hope everybody is safe and well and is not experiencing some of the issues that I have been seeing and that Dave and his gang have been seeing over the past few months. But I wanted to address them head on today so that we can make sure that you identify those issues in advance. If you are going through them now, you know how to navigate them. And if you fortunately have not yet, you will be prepared in the event that these issues do arise. As David said, we're more than happy to answer any questions at all throughout the presentation, and we will also leave a few minutes at the end. I know I've presented to a Diversified group in the past, and I really enjoy doing it because they often will ask a lot of great informative questions, and I certainly would encourage you to do so. With that, let's dive in, and we're going to start with the power of attorney. It is one of the core documents of an estate plan, and I will briefly discuss it as to what it does and then discuss some things that are specific to the pandemic. There are primarily 2 types of powers of attorney when we are discussing estate planning, and that is a general durable power of attorney and a springing power of attorney. There are other types like a limited power of attorney. Sometimes people will execute, but I'm going to primarily focus on those 2 because they're most commonly associated with estate planning. A power of attorney, just in general, is any written document that allows an individual, who is generally called a principal or agent, to designate someone to serve on their behalf to ensure continuity of the management of an individual's assets if they become unable to do so, or if they simply don't wish to do so any longer. They may be elderly and may have complete capacity, but don't want to be burdened with that, those issues relating to assets and other daily management. The objective of most powers of attorney is to designate someone to serve, and in the wake of the pandemic, I'm receiving more and more inquiries about this. Generally, a power of attorney, and while it varies state to state, requires a principal to be of legal age, generally 18 in most states is the age of majority, and competent at the time that the power is given. It generally requires to be signed in the presence of witnesses and a notary, and you will see that it is common throughout this presentation that we need witnesses and a notary, and that's presented a host of problems. Many states either had remote notarization laws on the books already, such as Florida, where one of the states that I practice in already had that. Many other states, such as New Jersey and New York and other northeastern states, have enacted laws on a temporary basis that will allow remote notarization. So what does that mean? Well, if you have access to Zoom or FaceTime or Skype or any other type of video conferencing platform, you can have the document in front of you and you can have a notary on the other end watching you sign it. You will then send that document to the notary, who then can stamp it or sign it depending upon the state laws. In some states, there are very specific requirements as to the exact software and other requirements, such as requiring the notary to save the video of the signing for a set number of years. So there are little intricacies and nuances from state to state, but it's important for all of these documents to know that there are options out there, and that just because we are in the wake of a pandemic, we can arrange for witnesses and notaries. I know in our Bear, Delaware office, not too far from David's office in Wilmington, we have a glass wall in between, almost like a doctor's office when you arrive. And so we have had, and it is completely blocked off. So it has worked very well to arrange for our two witnesses in our office to sit on one side of the glass. The client comes in and we are able to pass the documents pretty seamlessly. Everybody has their own pens. We have a glass window and have been able to arrange for a lot of signings. I have already arranged several in people's homes where the witnesses were standing outside the house looking through a window. Again, it varies state to state, but generally, if you have a direct line of sight to someone, then that is acceptable. I've already had a couple that have been executed in documents executed in their vehicles. And we had the window up and the person signed in the car and the witnesses were looking outside the window, one on one side on the passenger side, one on the driver's side. So there are creative ways, and if you are in a pinch and you need to get documents signed, we have not allowed this pandemic to be a roadblock. So in terms of the two specific types of powers of attorney we're going to discuss in the context of estate planning, the first is a general durable power of attorney. That document becomes effective immediately upon the principal signing it. So if I sign a power of attorney that is a general durable power of attorney today in favor of David, he immediately today has the ability to carry on all of my day-to-day financial affairs and otherwise. If I today execute a springing power of attorney in favor of David, that means that it springs into effect only upon my incapacity. And how is that determined? Well, generally, the document will spell out what constitutes incapacity. In many of my documents, and again, it does vary state by state as to what is permitted, I will outline what incapacity means and what that process entails. Generally, I will ask for the primary doctor of the principal to determine in writing that the principal is now incapacitated, or two other doctors to opine that the individual is incapacitated. A lot of my clients will say, well, I don't want to have to go through that headache. And there's a lot of practitioners and a lot of my colleagues and other attorneys don't like springing powers of attorney. They feel that it is just a significant hassle to have to go and obtain permission from doctors before an individual can act. I don't feel as strongly because there are a lot of clients that have younger children, even if they're of age that they've appointed. They may be in their late teens or early 20s, and they say, listen, if something happens and I do become incapacitated, yes, that's fine. I would want my child to step in. But if not, I don't want them to have access to all of my accounts. So it's something to keep in mind, and it is not a overly difficult endeavor to obtain the consent of a medical professional in the event that you wish to use a springing power of attorney. The second core document of an estate plan is a living will and advanced healthcare directive, which again, state by state have different terms, but generally, an advanced healthcare directive allows you to appoint someone, often called your agent or surrogate or medical proxy, to make end-of-life medical decisions for you. A living will usually complements an advanced healthcare directive because it outlines the wishes that you want your proxy to carry out for you. So if I sign an advanced healthcare directive today in favor of David, it may outline exactly who I want as the principal in terms of David to make those decisions and be the proxy, as well as any successors in the event that Dave is unable to serve. And then that will be accompanied by my living will. And that living will may outline my healthcare decisions, end-of-life decision-making, any religious preferences that are related to healthcare, and specific items that I may want to enumerate in my living will so that those wishes are carried out. It is generally prudent to provide a copy of this document and your other documents to either a spouse or partner, your adult children, or your primary care physician, so that that physician may include this document in your patient chart. You may also want to provide a copy to a local hospital, particularly right now where people are not traveling much. If there is one or two hospitals in your town where you know that if there is a problem, you will likely end up in one or two of those hospitals, you may want to provide this advance directive to the hospital, because if they don't have it, they may not know about it, and your wishes may not be able to be honored if nobody does know about it. You may also want to provide express authorization in these documents to allow your healthcare proxy to move you from one facility to another. It's an issue that I have certainly been seeing more frequently, as some facilities, particularly in places like New York, where I practice, were becoming overwhelmed and they wanted to get them out of that facility. If you already have this document in place and you wish to update it, it is a fairly easy process to do, but it is a good time to be reviewing these documents and ensure that if you had perhaps minor children at the time you signed it and now need to update it, or if your specific medical wishes have changed, or if you either became married or divorced, or there's a death in the family, then it is a good time to update not only this document, but all of your documents. I have several clients recently who are not married, but they do have a partner, and they didn't realize that if they didn't have this document, this advanced healthcare directive, then that person, their partner, who sometimes they've been with for decades and just weren't formally married, would have absolutely no ability to make any decisions. In the event that you don't have any healthcare directive, then they will go by this order of priority that varies state by state, generally starting with adult children or parents or siblings that will then be responsible for making that decision, and your partner may have absolutely no ability to do so. Now I want to discuss what's called a POLST order, a physician orders life-sustaining treatment order. It is becoming more and more prevalent. I've written articles about this going back to probably about 5-6 years ago when they first started to become enacted into law. There is a national POLST form, and then majority of states have now enacted this POLST form and will honor it. And it is similar to an advanced healthcare directive, except a POLST form does not allow you to appoint a proxy, a healthcare proxy or surrogate to make medical decisions. It is not a legal document, it is a medical order. And in this POLST form, you will outline very specific wishes for treatment, particularly in medical emergencies. I can think of one scenario recently where my client was a nurse, and so she sees a lot, and she had very specific wishes. She was a good candidate to complete a POLST order. Not to say that she couldn't complete those wishes in advanced healthcare directive, she did, but a POLST form will allow very specific medical wishes to be denoted in that document. And this is a document that is filled out by your medical provider and will give you certain boxes that you can check off, and it then better ensures that the medical facility will be able to carry out your wishes if you are admitted to the hospital. One of the keys to this document is that often the facilities will share these documents with one another. So once it goes into their system, the software is getting better and better amongst hospitals, even if they're not within the same network of ownership. And hospitals are starting to share this information with the consent of the patient. And the goal is ultimately to have a national database with all of this so that it would be in your chart as soon as you are admitted to a hospital. It is a completely voluntary form that is often given to patients when they are admitted to a hospital, so you should have some familiarity with what this term means, in that if you are admitted, you may be asked to sign this document if you don't already have an advanced healthcare directive. But again, the takeaway is I would strongly recommend that this is going to be a document that complements a living will and advanced healthcare directive and not a substitute, for the most important reason that you cannot specifically denote your surrogate and healthcare proxy in a post form. All right. Next is a DNR order, do not resuscitate. A lot of my clients come in and they say, I want to have a DNR order. And I say, well, I'm not sure that's exactly what you want. You may want to have a broader advanced healthcare directive, and part of that will have your wishes in terms of DNR. And there's been a lot of reevaluation recently as to DNR orders, and it is definitely not a universally accepted means of resuscitation and prolonging one's life is no longer universally accepted. There's a whole lot out there that people are now trying to denote their wishes that are outside of a DNR order. In many states, the DNR order may be issued during hospitalization that will take effect immediately. A DNR order does not constitute consent to withhold or withdraw treatment. That is a common misconception. That needs to be in the living will. It only applies to cardiopulmonary resuscitation, CPR. So if your heart stops or you stop breathing, that's when a DNR order will become applicable. In all of my advanced healthcare directive and living will documents, I have specific DNR wishes so that my clients can designate their specific wishes in there. But this is generally an insufficient document to outline what your wishes are. It is just one very narrow decision that you may make. This has become at the forefront. I just recently wrote an article on this in New York. Obviously, the state was hit the hardest, or certainly one of the hardest of any states by the pandemic. And a lot of medical professionals were faced with a situation where they were being forced to make decisions. And they didn't want to make those decisions. They wanted family members to make them, but they weren't able to find these documents. And so they were asking their patients to sign these DNR orders. And it was leading to a lot of confusion because in New York, the laws are much more complicated than a lot of other states that revolve around DNR orders and living wills and medical directives. So even if you're in New York, you certainly want to make sure that you have these forms in place. And if you're not, you just want to be cognizant, because so many people visit New York on a yearly basis, that if you were to be hospitalized, you want to ensure that the right people, your family members and others, know your wishes and they've been enumerated in your specific documents because of the so many issues that have arisen in New York recently. They actually just changed one of the laws. They were, because the hospitals were so overwhelmed, they basically were not resuscitating people. That was kind of the default, that they were not administering CPR unless they were specifically directed to do so. There's a document that told them to do so. And that is often not what people necessarily want. Okay, on to the next one. Another common one that we are seeing more and more of recently is that you have a lot of clients that are in their maybe 30s, 40s, 50s and have their planning in place, and their mindset is now turning to their parents who are elderly and they are incurring illnesses and they are having medical issues, and now they are being the ones that are being asked to jump in and become medical proxies. If your parent or other loved one is taken to a healthcare facility, or perhaps you're serving as a guardian or caretaker for another person, it is imperative that you carefully read any documents that you are asked to sign. If your parent or the person that you are caring for is experiencing cognitive impairment, then they may be unable to sign a legal document, and just by you taking them into the facility, that a medical facility may ask you to sign certain documents. And if you sign your name in lieu of the patient's name, you may be consenting to incurring certain medical debts. And I have seen this way too many times. It is very, very prevalent in more long-term care and rehabilitation facilities, but I've also seen it from hospitals and other medical facilities where they sign on a line that says responsible party, and that person, whether it's the child or someone else that's a caretaker, thinks that they are the person that is going to be contacted in the event of a medical emergency. And so they sign on the line that says responsible party, not realizing that right above it, it says that they are responsible for all of the financial debts that may be incurred from the treatment that is being provided. When they didn't need to sign it at all, they would still be admitted. They can't be refused any medical treatment under a bunch of federal laws, but most recently under the Affordable Care Act. That can't happen. So be very, very careful if you are going in and bringing someone else to a facility that you do not sign as a responsible party. I've also seen separate documents where individuals think that they are just signing and they are going to be the attorney in fact or make certain decisions, and then they realize that on the back of the page, or very small fine print somewhere in there, it says, by signing this, you're accepting complete responsibility for all financial affairs, and it could literally bankrupt people. And there was no need to sign it. The person was still going to be admitted. One other important point is that if you are taking care of another person, make sure you have all of their insurance information. If they have supplemental insurance, it is very important to have those documents, and make sure that you have a list of the healthcare facilities that are covered under that insurance plan. Again, particularly for people that are elderly, they may not be traveling nearly as much, and particularly in the wake of the pandemic, not traveling as much. So identify that healthcare facility that is closest, that is covered under the insurance plan, and have it lined up so that you are not scrambling in the event that there is a medical emergency. All right, on to the third core document of an estate plan, and that is a last will and testament, also known just as a will. Similar to what I was discussing with the powers of attorney and living wills, there are some ways right now that we have been creatively arranging for these documents to be signed. One of them is through what's called a holographic will. A holographic will is one in which a person writes it in their own handwriting and then signs it. It often, in many states, and again, every state is different. Some states don't allow holographic wills, but a lot of states do. And if it does, often if you write a will by hand in your own handwriting and you sign it, you do not need to do so in the presence of witnesses or a notary. So we have had some clients who have prepared very basic wills that they have written in their own handwriting just to tide them over. And in a couple of other circumstances, we have had clients create what's called a pour-over will, which is a will that is very simple, that states that any assets that individual, the person who creates a will, is called the testator, or the female version is often called a testatrix in many states. I will use the term just testator in general terms, and that a testator may create a pour-over will that says that all assets will become part of their trust, a revocable trust. And a trust in many states does not need to be signed with the same formalities as a will. So some people may have a pour-over will that they write by hand, and they say, I leave all my assets to my revocable trust dated June 2nd, 2020. And then the trust can be prepared by an attorney and properly prepared. And now that trust may not necessarily need to be signed in the presence of witnesses and a notary, again, depending on state law. Generally, anybody who is of sound mind that knows the nature and extent of their property and knows what's called the natural objects of their bounty. That is the legal phrase that is commonly used in most states, meaning you know who your immediate family is. If you're married, you know your spouse, you know your children, you know any grandchildren, you know any siblings, anybody you may be potentially devising property to, you know who they are. So if you're of sound mind and you know the natural objects of your bounty and you are of legal age, basically anybody can create a will. And generally, it will need to be witnessed in the presence of generally two witnesses, and a notary is common. But there are ways, as I mentioned, around that. And there are ways to also make arrangements to sign those documents, as I mentioned, things like looking through a glass door. So if you're unable to hire a professional to draft your will in light of the pandemic, there are some options that you may be able to work around. And so the last document is that revocable trust. And the revocable trust is the document that can control disposition of assets. It is a document that allows you to avoid probate administration for any assets that are owned by a revocable trust. And the key to a revocable trust, it is very similar to a will. It does not provide asset protection. It can provide a lot of flexibility because you can change it or modify it at any time. But any assets that are owned by your trust will pass outside of probate when you pass away. So the most common misconception is that they hear the word trust and they either, one, think that it's going to be very expensive and involved and complicated, which is not the case, and two, they think that it provides them asset protection, which it does not. That only applies to irrevocable trusts. So that is, in a nutshell, the most core documents. I would certainly welcome any questions or comments, and Dave, certainly feel free if you have any. And as Dave mentioned, I am extremely accessible. You can call me, email me, anything you want. I'm always more than happy to answer questions and be a resource. Dave, I'll turn it back to you.
Yeah, thank you, Michael. That was very informative, and to everyone listening, Mike has been a valuable resource to our organization and our clients, and will continue to be so. So let's see if there's any questions. I didn't have any come through. If anyone has any questions, go ahead and write them in the question section, and we'll ask Mike. Otherwise, let's give this a second. Doesn't appear any are coming in, but we'll call it a day. We'll let everyone get back. Mike, thanks for your time and this information, and everyone that's listening, thanks for tuning in. And as always, we record these and we'll have them posted on our website for easy access. Please feel free to share it with anyone you think would find value in this information. And one piece of housekeeping is our next wealth webinar series. The next installment will be August 12th for our mid-year economic market update. And everyone have a great day and stay well. Thanks again. Bye.
Thanks, Dave. Bye-bye, everyone.